Welcome to another episode for our random bar questions. We will be starting with another set of questions for today. Once again, we would like to thank everyone who are joining us, especially our first followers here in Facebook. We are very much grateful to your support. Again, we would like to remind everyone to please help us grow this Facebook page so that we'll be able to help more people by rating this podcast at the same time sharing this in your Facebook page. All right, so this time let us start with another set of questions for today. All right, so the first question is about loss of possession. No. Ribolida owned a platinum ring kept in a vault of La Estrella del Norte. But one day the ring was stolen and found in the possession of Bustamante, who in good faith had purchased it from the passing peddler Gargantilla. Can Ribolida get back the ring without the necessity of reimbursement? Okay. Again, okay, in this case, the following are the facts. Ribolida owned a platinum ring kept in a vault of La Estrella del Norte. But one day the ring was stolen and found in possession of Bustamante, who in good faith had purchased it from a passing peddler, Gargantilla. Can Ribolida get back the ring without the necessity of reimbursement? Okay, what do you think is the answer? Okay, so the answer is yes, since the stolen ring had been acquired through, though in good faith, at a private sale and not a public one. Thus, there is no need of any refund of the purchase price. This action for Replevin will therefore prosper. Okay, again, since the stolen ring had been acquired, though in good faith at a private sale and not a public one, there is thus no need of any refund of the purchase price. Thus, the action for Replevin will therefore prosper. All right, let's proceed. What are the rights of the possessor? What are the rights of a possessor in the concept of an owner regarding fruits if in good faith? What are the rights of the possessor in the concept of owner regarding fruits if in good faith? Okay, so this includes, no, what are the answer? What are the answers? Okay, so this includes gathered or severed or harvested fruits are his own. That's Article 544. See also the case of Nacoco versus Geronimo, decided on April 29, 1949. And it also includes the pending or the ungathered fruits. Prorating between the possessor and the owner of expenses. That includes the net harvest and the charges. Okay, see Article 545 of the new Civil Code. Okay, let's proceed. What if the person to be arrested is hiding inside the building? Okay, what if the person be arrested is hiding inside the building or enclosed and he refused to admit thereto after announcing his authority and purpose? What are you going to do? Okay. Again, what if the person to be arrested is hiding inside a building or enclosure and he refused admittance thereto after announcing his authority and purpose? What are you going to do? No. So the answer is that the officer, in order to make an arrest either by virtue of a warrant or without a warrant as provided in Section 5, may break into the building or enclosure where the person to be arrested is or is reasonably believed to be. After entering the building or enclosure, he may break out therefrom when necessary to liberate himself. All right, let's proceed. All right, let's proceed to the next question. Next question. What are the different types of illegal recruitment under the Labor Code? Again, what are the different types of illegal recruitment under the Labor Code? No? So what do you think? Okay, the answer is that this includes the following. This includes simple illegal recruitment, Illegal, that's number one, simple illegal recruitment. Number two, illegal recruitment considered as an offense involving economic sabotage, which can be further classified to illegal recruitment committed by a syndicate and illegal recruitment committed in large scale. So take note, under illegal recruitment involving economic sabotage, there are two kinds. We have illegal recruitment and illegal recruitment committed by a syndicate. So it could be more than three people. And illegal recruitment committed in large scale, wherein the victims are more than three people. Okay, so take note of these kinds of illegal recruitment. Okay, by the way, just to make it clear, illegal recruitment committed by a syndicate in a large scale shall be considered an offense involving economic sabotage. Illegal recruitment is committed by a syndicate when it is committed by group of three or more persons conspiring or confederating with one another. Take note ha, three or more persons. Okay? So don't forget that. And then illegal recruitment is committed by large scale if committed against three or more persons. So if four, illegal recruitment pa rin, no? Involving economic sabotage. Okay, let's proceed. All right, so this question involves question about liabilities. A was approached, no? A was approached for a possible overseas deployment to Dubai. Okay. So this is the story here. So A was approached for a possible overseas deployment to Dubai by X, no? Kani si X good. Oh. An interviewer of job applicants for Alpha Personal Services Incorporated. So si X is actually an interviewer. And then an overseas, by the way, this Alpha Personal Services is an overseas recruitment agency. So take note of that. X required A to submit certain documents like passport, NBI clearance, medical certificate, and to pay 25,000 pesos as processing fee. Upon payment of the said amount to the agency cashier, A was advised to wait for his visa. After 5 months, A visited the office of Alpha Personnel Services Incorporated, during which X told him that he could no longer be deployed for employment abroad. Okay, patay. A was informed by the Philippine Overseas Employment Administration that while Alpha Personnel Services Incorporated was a licensed agency, X was not registered as its employee. So, hindi pala siya talaga employee. Huh? And then under under the POEA, no, that's the Philippine Overseas Employment Administration rules and regulations, the obligation to register personnel with the POEA belongs to the officers of the recruitment agency. May X be held criminally liable for illegal recruitment? No? Explain your answer. May explain pa. Okay, try to answer this. Okay. The answer is no. No. X performed his work with the knowledge that he works for a licensed recruitment agency. He is in no position to know that the officers of the said recruitment agency failed to register him as its personnel. So please read the case of People versus Chowdhury. No? The fault not being attributable to him, he may be considered to have apparent authority to represent Alpha on recruitment for overseas employment. So this is actually the theory of imputed knowledge. Under the theory of imputed knowledge, it is considered a doctrine in agency stating that the principal is chargeable with and bound by the knowledge of or notice to his agent received while the agent was acting as such. So what does this mean? No, whatever it is that the agency is acting upon, no, the principal will be liable. No, just imagine this is more of a if it's under your custody, then you will be liable, no, for for what your people has committed. Yes, however, it could not be the other way around. No, whatever the offense of the principal is not attributable to the agent. Okay, so in this case, please take note that the agent here is actually X, no, and it is actually the offense of the principal in this case because of their failure to register him in the POEA. So he is not liable for such. All right. Let's proceed now to the next question. Okay. The next question is, how is retirement benefit under a collective bargaining agreement or considered applicable contract? No. Again, how is retirement benefit under a collective bargaining agreement or okay. Okay, let's proceed to another question. The question is, how is retirement benefit under a collective bargaining agreement done? Okay, so how is it done? Okay, any employee may retire or be retired by his or her employer upon reaching the retirement age established in the collective bargaining agreement or or other applicable agreement contract and shall receive the retirement benefit granted therein. However, that such a retirement benefit shall not be less than the retirement pay required under RA 7641 and provided further that if such a retirement benefit under the agreement is lesser and the employer shall pay the difference. No? So those are the important guidelines. Okay, next question. When is a barangay certification required? Again, when is a barangay certification required? Okay, this is required when the crime or offense is punishable by imprisonment of not more than 1 year or a fine not exceeding 5,000 pesos. So take note, ha, it is only applicable, the barangay certification is only applicable if the offense is punishable by imprisonment of not exceeding 1 year or a fine not exceeding 5,000 pesos and the parties to the case are all residents of the same city or municipality, and the complaint shall be accompanied by the certification required under Section 412 of RA number 7160 or the Local Government Code of 1991. All right, so please take note. Okay, next question. Deeds of release, waivers, and quitclaims are always valid and binding. So, okay, is it true or false? Again, is it true or false? Okay, how do you answer that? Okay. All right. The answer is false. The deeds of release, waivers, and quitclaims are not always valid and binding. An agreement is valid and binding only if the parties understand the terms and conditions of their settlement, and B, it was entered into freely and voluntarily by them, and it is not, if it's not contrary to law, morals, and public policies. Again, deeds of release, waivers, and quitclaim are not always valid and binding. An agreement is valid and binding only if the parties understand the terms and conditions of their settlement, it was entered into freely and voluntarily by them, and it was contrary to law, morals. It was not contrary to law, morals, and public policy. Okay, another alternative answer is that you can also say false. Not all deeds of release, waivers, and quitclaims are valid and binding. The Supreme Court in Periquet versus NLRC, no, and affirmed in Solgos Corporation versus Court of Appeals provided the following guideposts in determining the validity of such release, waivers, and quitclaims. Not all waivers and quitclaims, no, this according to the Supreme Court, are invalid and as against public policy. If the agreement was voluntarily entered and represents a reasonable settlement, it is binding on the parties and may not later be disowned simply because of a change of mind. So hindi pwedeng you just change your mind. But where it is shown that the person making the waiver did not so voluntarily, no, and with full understanding of what he was doing and the consideration the quitclaim is credible and reasonable, the transaction must be recognized as valid and binding undertaking. Okay, so please take note of that. Let's proceed. Okay, next question. What is the precautionary principle? This is for environmental law. So what is the precautionary principle? Okay. All right. The precautionary principle is Principle 15 of the Rio Declaration, also known as the precautionary principle. It states, in order to protect the environment, the precautionary principle shall be widely applied by the states according to their capabilities. Where there are threats of serious and irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. Okay, so please take note that the precautionary principle allows us to actually start protecting the environment without the need of full scientific proof that there is possible damage. You know why this is? Because the law believes, no, that it's more important to protect the environment than to wait for scientific reasons and results to prove such damage, because whatever damage we can have in the environment can actually cause irreparable damage, no? So might as well as make sure that we avoid that possible damage to occur, no? So that's how well our laws are protecting in terms of protecting our environment, no? So let's proceed. All right. So question, what are the possible grounds by which the Secretary of Justice may dismiss the petition? Again, what are the possible grounds by which the Secretary of Justice may dismiss this petition? What do you think? Okay. These are the possible grounds. No? Affirm the decision of the prosecutor and dismiss the petition based on the following grounds. That the petition for review was filed beyond the prescribed period. So that's the first one. If the petition was actually filed beyond the period prescribed, then you have to actually dismiss it. Number two, that the prescribed procedure and requirements provided in the Department Circular 70 were not complied of. So take note of that. That there is no showing of any reversible error, or that the accused was already arraigned when appeal was taken. So after the arraignment na. And alas, that the appeal resolution is interlocutory in nature. So what do you mean by interlocutory? It means that the resolution is the decision was actually made and it's not final, no? When it suspends the proceedings based on the alleged existence of a prejudicial question. Okay, take note of that. All right, let's proceed to our last question. According to RA 7691, okay, again, according to RA 7691, how should the Supreme Court exercise the power granted to define the territory over which branch of the RTC shall exercise its authority? Again, according to RA 7691, how should the Supreme Court exercise the power granted to define the territory over which the branch of the RTC shall exercise its authority? Section 18 of RA 7691 of such act mandates that the power granted shall be exercised with view to making the courts accessible to the people. So take note, that is actually the essence of it. We want to make the court more accessible to the people of the different parts of the region, making the attendance of the litigants and the witnesses as inexpensive as possible. Lah, may buto. All right. All right. So once again, we'd like to thank everyone for actually joining us with another episode. We're making this episode for our people who are taking the bar, and of course for those law students who wanted to review with us. And also, we'd like to shout out to all the followers of this Facebook page. We would like to request that if you enjoyed this podcast, please make sure to follow and like, this video, and to share it in your Facebook. We are very much thankful to your support, and we are praying that we'll be able to upload more content, to help the bar takers, at the same time the law students who wanted to review with us live here at this page. Thank you, everyone, and I'll see you tomorrow for another random questions here in this Facebook page. Thank you and God bless.